Good morning, good afternoon, good evening, wherever or whenever you may be. This is the overnight. I am Liam Voss, and with me uh, is Baron SVG. How's it going, Baron?
Pretty good.
And let's see who was out there so far. We had G23, um, which I laid down to take a nap, G23, and woke up at like 9 o'clock. So I missed your chat. C&T Designs and Arms, Iron Road, Mike McClune, Hillbilly Up. And is that everybody that's been talking? Oh, wait, that bearded guy?
DJ's out there.
Oh, yeah, DJ was first.
Woods is out there.
Wait, I'm getting to him. Hold on. PNW Woods saying go Cougars. And I think that's everybody that said something so far. Ron Wayne jumping in there. So tonight we were going to cover the Fifth Amendment. And can you call up the? I don't have it.
Yeah, you want me to read it?
Yeah, go ahead and read it.
No person shall be held to answer for a capital or otherwise infamous crime unless unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. It's a mouthful.
So let me see. Mrs. Wayne jumped in there. And before we get going, let me get their banners going. So at the bottom of the screen, there's an email and a link if you want to send in suggestions, comments, pictures of stuff within reason. Those are two ways to get there. And I don't think I put it in the description this week, but the Gilded server for the overnight Gilded server.
It's on the banner.
It's on the banner. It's a place to kind of hang out, share memes, chit chat with each other.
The overnight.live.
And you can always get a hold of me or Baron. There, we're always on there. And
feel free to complain and name call.
Yep. Oh, and if you watch this in replay, leave a comment. Let me know you watched it. Anything we talked about. Think we got right. Think we got wrong. Think we left out. I always appreciate constructive criticism. It helps me get better at doing this stuff. I want to hear what people think. And I always read the comments. We had Homeless in America. Yes, I am in Washington. We are actually, Baron and I are both in Washington.
Pray for us.
So this week is the Fifth Amendment. And when you Google the Fifth Amendment Supreme Court cases, you actually don't get a lot from Google. You have to really start digging to find stuff. Oh, he's in Everett. So you're north of me.
Being homeless in Everett must suck.
Have
you considered Los Angeles? Nicer weather.
see. Oop, forgot what I was doing here. So one of the things I came across was from the annenbergclassroom.org. There we go. And I've looked at their website for some of the other ones. They'll give a timeline for each of the amendments. They don't go too in depth, but they give you kind of in big moments that happen, and then the year, and we'll cite cases in some of them, so you can look up cases based on that. That's kind of what I did for part of this one. But so I thought we'd use that as a basis, just because I was having a little trouble this week. And so for the 1784 New Hampshire Constitution adds the first double jeopardy clause, that no subject shall be liable to be tried after acquittal for the same crime or offense.
Now, do you think they did that because they're not including anything since before our country started, or there was nothing to show? Because they used to torture you until you admitted to your crimes.
I don't know.
Okay, I'm going to go out on a limb and say there was no protections for you not to be forced to be a witness against yourself until then.
The Crown could decide that they don't like you, whether they feel that you're a threat to their power or they just find you annoying. Say that you committed a crime, not present any evidence that you committed the crime, convict you for that crime, and then put you away somewhere so they don't have to deal with you anymore.
Torture you until you say you did it or die. And they're like, well, I guess he was innocent because he didn't admit to it and he died. Fuck.
Yeah, that's, that all the torture devices, some of them which weren't real, but, like the rack and the pear, the pokers in different places, red hot pokers. So that the fifth gives you some rights where the government can't just decide that they don't want
protections.
Yeah. So 1789, it was proposed. James Madison proposed his amendment to the Constitution, which will become known as the Bill of Rights. He includes a constitutional provision that an individual shall not be compelled to be a witness against himself. Congress adds the words "in any criminal case," meaning that the provision, which will become known as taking the fifth, will be allowed only in criminal trials, not civil ones. This will become one of the Fifth Amendment's clauses providing safeguards against abuse of criminal laws. In 1791, it was ratified. In 1791, the Bill of Rights was ratified. So 1856, seizure of property without full hearing allowed. And this, so the court is Murray's Lessee versus Hoboken Land and Improvement Company. And to determine the constitutionality of a procedure, the court looks at whether it violates specific safeguards in the Constitution. And this has to do with debt. So the government can take your shit if you owe them money without a hearing. That's basically, and this comes up. There were a few court cases that I found, Supreme Court cases that dealt with this, where they say that it's not being basically, since it's not being taken for public use, it's being taken because you owe money. That is permissible. 1875, Cole versus United States. Government can take over private property for its use. Supreme Court holds that the federal government takeover of land in Cincinnati, Ohio for a post office and eviction of the tenants. The court rules the ability of the government to exercise its eminent domain power in the Fifth Amendment is essential to its ability to fulfill all of its duty to the public. And this important goal outweighs any inconvenience to the individuals living on the land. The court also finds that the amount of the tenant's compensation should be determined by the federal court, which later on, I think it's set to market value. So I don't know how in 1875 they determined what the value of the property is.
Probably unfairly, if I had to guess.
Well, that was actually a problem in Washington where property taken. This was 20 years ago or so. There was a big to-do about the state taking property, and
It's for a highway, right?
I don't remember the specifics of it, but the fair market value that they were claiming was less than what the property owners were claiming fair market value was. But I think they got shafted a little bit, and the state said this is how much it's worth. This is what you're getting. And there's other. I think we'll probably cover it a little bit later, but the state took property not to use for a highway or anything like that, but to sell to another company, because that company, the profits, that the taxes from that company, they were saying is a benefit. So that went to I believe that went all the way to the Supreme Court, and it was upheld, where the state could take the property to sell to a company because it would make more money from the taxes from that company.
Sounds like something Washington State would do.
And there was somebody, one of the Supreme Court judges who voted in favor of that. Somebody in their state, I can't remember if it was a senator or a representative, tried to get the Supreme Court justice's property taken under eminent domain. But I don't think that went anywhere. Yeah,
your family could live on a plot of land for like 300 years. You got graves there that go back to when you first settled it. They don't give a fuck. They'll just take it, kick your ass off.
1889, second trial for the same conduct violates double jeopardy clause. In Nielsen, which I did not look up this one. The Supreme Court rules double jeopardy clause is violated by the attempt to prosecute a defendant for adultery when he already had been convicted of unlawful cohabitation. Because of the cohabitation conviction meant the defendant had been found guilty of living with a woman whom he was not married. The adultery offense was included in that conviction and could not be a basis for a new criminal charge. The defendant, a Mormon, was charged with these crimes because he lived with multiple wives.
Oh, the humanity.
Yeah, I don't think this is one that'll come up anymore. There, well, I'll save it because there's stuff that'll come up later in the timeline, kind of having to do with the double jeopardy. But I'll say the double jeopardy, a lot of the Fifth Amendment only applied to federal courts at this time. They did not apply to state courts. So there's a lot of these protections that you don't get right, at this time in state law. So 1896 government projects does not have to be a benefit to all members of society to be a public use. That's Fallbrook Irrigation District versus Bradley. Supreme Court upholds a California law that imposes a tax on landowners to pay for irrigation of drier lands in the state. So that's one thing that comes up in Washington, where a lot of the taxes are set by Seattle and kind of Tacoma, the large cities over in the west, and the east side of the state doesn't see as much benefit from what the taxes imposed by the west side of the state, which controls the state. The court notes that irrigation project qualifies as public use, even if only certain landowners will benefit, because it helps the state's economy as a whole. And that kind of touches on what I was saying about the Washington state taking the property for the taxes, selling it to a company to get the taxes. Notably, this case is decided before the takings clause is extended to the states, and thus relies on the 14th Amendment due process clause rather than the Fifth Amendment. The 14th Amendment really has an effect. It mirrors a lot of the earlier amendments, but applies it to the states. 1897 court, not every public use requires just compensation. So I just saw Coop was saying federal constitution only applies to federal matters. That's why states have their own constitution. At least that's the way it's supposed to look. Woods is going to bed. Have a good night, Woods. And hopefully I don't miss too many of the comments as I'm reading. If I do, I apologize. So in Chicago B and QRR versus Chicago, Supreme Court rules that a city's decision to build a public road across some railroad tracks, which requires the railroad to incur the cost of erecting gates, planking the crossing, and maintaining flagmen in order that the road may be safely operated, is not taking. So the city put a road across the railroad tracks, and the safety requirements because of that road are not. It's putting a burden on the railroad company, but it's not considered taking from them, is what that's saying.
So it'd be like if I had a pond on my property and they built a school next to it and they're like, hey, you need to put a fence up so these kids don't drown. Yeah. Kind of like that.
1898, no absolute rule for how to calculate just compensation. Backus versus Ford Street Union Depot Company. The U.S. Supreme Court upholds a lower court's decision that reduced a manufacturing plant's owner's compensation when the street in front of the plant was condemned for use by a railroad. The court rules that the measure of damages was fairly set by a jury that was instructed to award full and adequate compensation. The court refused to set an absolute formula for calculating just compensation under the Fifth Amendment. All that is essential is that in some appropriate way, before some properly constituted tribunal, inquiry shall be made as to the amount of compensation. So you get what you get as long as it's considered fair. So Hillbilly Up saying here in 1953, government took 300 acres from a family for $10 per acre due to the possible flood stage from a new lake. In 1985, government sold that for $10,000 per acre. Now it's a private golf course and condos. Yeah.
Sounds about right.
And Ron Wayne said he sent in some Gorin, and so we'll look at that later after we get through the timeline. So, 1922, a hearing required before deportation. In Ng Feng Ho versus White, the Supreme Court rules that the Fifth Amendment due process clause requires the government to hold a hearing before deporting a U.S. resident who claims to be a citizen, arguing that otherwise the person is deprived of liberty and possibly in danger of losing property and life. I don't really have a problem with that one.
Otherwise, it could just be like, Voss, you're not a citizen. We're deporting you to North Korea. What the fuck? Do I get a trial?
Yeah.
No, you're not a citizen. We just told you that.
Isn't that
See
the
you later.
basis for the song in the movie Born in East LA?
Yeah, that's crazy.
Oh,
By the way, how'd you know how to pronounce that?
Ing?
Ing? This?
Ing.
Okay.
Because it's Ing. That's how you pronounce it.
I wouldn't. Yeah. Nope.
Yeah, it's not Nug. Ing.
That's what I would have done.
1922, conviction in both federal and state courts, not double jeopardy. A defendant who has been convicted in a state court objects to having to stand trial in federal court for the same crime. U.S. versus Lanza, Supreme Court rules that the double jeopardy clause was not violated because the states and federal legal system are different government units, and that each can determine what shall be an offense against its peace and dignity.
Lanza. Okay, not the Lanza I'm thinking of.
Tony Lanza?
No.
Who's the boss?
Oh, yeah, duh. It's 1922.
So in 1922, law requiring mining firms to pay for damage after sale struck down. I don't think I even read this one when I was looking at this one. Coal mining companies that were primarily interested in the coal beneath the land surface often sold the land above the mine, but only the surface rights. Sometimes, and that's what, when you hear mineral rights, that's what they're talking about. What's in the ground, not what's on top of the ground. I think.
I want to buy aerial rights. So no one can fly a drone over my backyard? How do I get that?
So there were special supports to be installed in the mines when the coal was
Removed.
removed to prevent cave-ins, but not always, because it costs less to buy surface rights without requiring companies to guarantee supports. That'd be pretty shitty if somebody develops on top of the unsupported
laugh.
mine and then sells it to you.
Yeah, you buy a house, and the guy's like, "Yeah, here's the deed," and then he digs a hole under your house, and it collapses. He's like, "Huh? Well, you only own the surface. Now the surface is lower than it used to be." Fuck.
So there was the Kohler Act was passed in Pennsylvania to prevent the public from these accidents, but the court finds surface owners, surface dwellers, knew that they only had limited rights to the property when they bought the land, and they must absorb the risk and the cost of any repairs unless the contract specifies the coal company is liable for damages.
That's what I'm gonna call all of our friends from Pennsylvania now. Surface dwellers.
I understand that. That's kind of interesting. I find that kind of interesting. That
Yeah, that's fucked up.
on one
Because
hand,
there's like whole towns that are built on top of a coal mine.
yeah. So the original purchasers will know if there's a problem, a potential problem. But do the subsequent owners know? I think now there's laws in place where it has to be divulged. Like when you sell your house, if there's a problem, you have to say what problem
disclosure.
your house has. But
there's ways out of that, which I'm learning recently. If they're not aware of it, then they're not legally liable for not disclosing it. How do you prove that they knew that an outlet was like catching on fire every week? That's the problem.
Yeah, it would have to be plainly obvious. I would think to prove it in court.
At that point, it's not really worth it, unless like your house burned down, something like that.
Yeah. I don't know what these scorch marks were. I just thought they were a paint job.
There's actually a way. If they never lived in the house and they rented it, so like they bought a house and immediately rented it, the disclosure agreement, they can just write never occupied house and they don't have to disclose anything at all. It's fucked up.
Yeah. Well, as long as they disclose that they don't know anything about the house, then you know that they're, if you don't have it inspected, you know there's potential problems. Well, it's not that you know that there is a possibility of problems.
Very risky.
That you don't know about. Yeah.
Yeah.
So you're the one that's taking the risk. But you know you're taking a risk because
you have to sign the disclosure agreement when you're buying. You're like, yeah, I agree. He said that he doesn't know anything about this place. He's never lived there.
Wesley, Mike McLuhan said he's from PA, and that applies to fracking also. Mineral rights and building on top. And Wesley Foster said in Massachusetts, they sell the ability to build on top of the actual turnpike. We have hotels in the Newton turnoff, which has a Sheraton hotel on it.
Not sure I understood, but interesting.
And also asked, do you have any objections to a pizza delivery drone flying over your house? Well, it doesn't really matter because you can't stop it. I probably
What if I have
wouldn't
a
care.
hawk sanctuary over my place and they just happen to take out drones accidentally?
It is kind of interesting to see the videos of when the birds will attack the drones and stuff.
Hmm. Free pizza. Here we go. Self-incriminating applies in criminal or civil cases versus criminal.
So, in McCarthy versus Arnstein, I think I put there for some of these cases. There are links in the description. I don't remember, honestly, don't remember which ones I put in, and then there probably are. I don't remember how many links I actually put in there.
Let me check.
Some may be. I know some are from this timeline, and then some were before I did this.
Do you have any from the alternate timeline?
Yeah, they wear the evil mustaches
Mm-hmm.
and goatees.
Goatees. I already got mine, so I blend in.
So the U.S. Supreme Court rules that debtors testifying at his own bankruptcy hearing is allowed to refuse to answer questions because his answers might incriminate him. The court holds that the Fifth Amendment privileges against self-incrimination applies to defendants in civil cases, not just criminal defendants, when criminal prosecution might be a result from the disclosure. I think the key part is when prosecution might be a result from the disclosure. So if I owed Barron $15 because he bought $15 worth of bubble gum from me, or I bought 15 from him. Sorry, I got it backwards.
If you owed me $15 for taking my likeness and making stickers out of them.
Yeah. And then you take me to court.
Uh-huh.
There is not, I don't think there would be a likelihood of criminal prosecution, if it's a small claims court. So I couldn't take the fifth.
Yep.
1937 double jeopardy clauses does not apply to states. In Palco versus Connecticut, the U.S. Supreme Court rules that double jeopardy protections do not extend to defendants in state criminal trials. The court says that while some fundamental rights, such as free speech, apply to states through the 14th Amendment, double jeopardy protection is not one. And
How the fuck does that work?
well, when the 14th Amendment is passed, what we have today protected by the 14th was slowly implemented. So little parts here, little parts there. It didn't all happen at once. And apparently in 1937, it wasn't happening right there. And this is kind of one thing that you see with all the amendments in the Supreme Court is you get a judgment from back here in time, and then you get a judgment more recent, which overrules the previous judgment. And so it changes the way that the laws are implemented and how your rights are viewed. And that's why who the justices on the Supreme Court are important, because they are supposed to be the final word, but that final word can change.
Yeah.
So if in the future they decide, oh, slavery wasn't that bad, you know, it was outlawed by Congress, so that's probably a bad example. But
They
like,
theoretically could bring it back if the nation lost its mind.
yeah. So we talk about the Second Amendment a lot on my channel, and you look at how it was interpreted prior to New York rifle, pistol, and whatever versus Bruin, and then how it's being interpreted now, the changes that have happened now because of that ruling. And that ruling goes against previous rulings that allowed infringements. And in the future, it could change again if the makeup of the court changes.
Yeah, you can almost guarantee it's going to happen eventually.
I do think so.
Unless we have a massive change in public perception about guns.
Yeah, that's that's one of the things that I try to do is be a representative of the gun community and reach out to those who are either not gun people, or just getting into guns, because even within the gun community, there are people that are okay with infringements. So, if somebody has a differing opinion from mine, they may not change their opinion on their own. By having a rational conversation with them may affect them, may not. You never know, but it's more likely to change their opinion.
Yeah, there's no downside.
I don't think so. It can be frustrating because a lot of people don't want to hear it. They are set in their ways, set in their beliefs. They don't care. And there's people you're not going to reach. But, you never know. You plant that seed, just by talking to them, not shouting at them. You cannot shout somebody into changing their mind.
Or name call.
Truly believe that.
Yeah.
And it's, it happens sometimes. You get frustrated. I understand that. But, the more reasonable of a conversation you can have, I believe, this is my belief, the more likely you can change somebody's mind.
I fully agree. I'm with you there.
Yeah, I'm starting to sidetrack us here. So, where were we? So, 1943, restrictions on Japanese Americans upheld. Yeah. Hirabashi.
Due process? What the fuck's due process?
Well,
this is World War II.
I understand the reasoning in this. I don't agree with it, but I understand it. In Hirabashi versus the United States, the Supreme Court says a federal law passed after Pearl Harbor that requires Japanese Americans to live in restricted areas and obey curfews does not violate their Fifth Amendment right to due process. The case involves the conviction of Gordon Kiyoshi Hirabashi, a Japanese American college student who had refused to register for relocation and had violated the curfew. The court does not address the relocation issue and instead focuses on the curfew, which it deemed necessary for protective measures. So this is where the hang on, I gotta go up here. It's like the
You want me to read the fifth?
Yeah, read the fifth again for me real quick.
Except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger.
So that's the clause that
public
basically
danger
would override the fifth, is because we were now at war, and so it's kind of
damn your rights. You're going in a cage.
Yeah.
Yeah, not
So,
good.
like I said, I don't agree with it, but I understand the reasoning behind it. 1946, Congress can define the amount of land needed for public use. Yeah, I'm going to kind of skip that one. So basically, just saying that they decide they need this much land, then that determines they needed that much land. 1948, secret trials violate due process right. Why it took until 1948, I don't know. And Oliver versus the U.S. Supreme Court overturns the conviction of a Michigan man who was convicted and sentenced against a secret grand jury hearing before a single judge. The hearing had occurred under Michigan law, allowing a single judge to hold a secret grand jury proceedings. The court does not rule on the law because it was not challenged by the defendant, and the grand jury proceedings held to decide whether to issue an indictment traditionally are conducted in private. In this case, a one-man jury went further when the judge also decided the defendant's guilt and sentenced him to jail. So I think the issue here was it was just one person deciding all of the points of the case.
Yeah, because you have the right to a trial by your peers. So if it's secret,
And that's what, a lot of the due process part is, because you had what was the Star Chamber. I don't know if you've ever heard the term Star Chamber. Basically,
I have
is
not.
like a secret court that England was using. So, you can disappear and, you have the right to face your accuser. You have the right to, I think those come up in the other rights that we're going to cover here. But, so it was just the one judge who decided this was a case that should be heard. Then he heard the case and then sentenced him. So there's not a lot of due process in that.
Judge Dredd is a British comic.
1951, right against self-incrimination broadened in Hoffman versus United States. The Supreme Court rules that a witness has the Fifth Amendment right to refuse to testify only when the testimony alone might support a criminal conviction, but also when the witness has a reasonable fear that testimony might assist the government in building a criminal case against the witness, such as providing a link in the chain of evidence needed for prosecution. So
Yeah, that makes sense. It's like if you and I killed someone, they wouldn't be able to force both of us to testify against each other. Be like, oh, you're not incriminating yourself, you're incriminating the other guy.
Ron Wayne is saying Star Chamber sounds like a 1970s sci-fi. There was I think it was a 70s or 80s movie called The Star Chamber. 1955, no magic word needed to trigger Fifth Amendment privilege. MSPAC versus the United States. Supreme Court rules that a witness before the House Un-American Activities Committee who refused to answer certain questions about his affiliation with the Communist Party is protected by the Fifth Amendment right against self-incrimination. The court says that the witness should not have been convicted and fined for contempt. The court holds that for a witness to be allowed not to answer the question on the Fifth Amendment grounds, he need not say any particular phrase. All that is necessary is an objection stated in language that the committee may reasonably expect to understand as an attempt to invoke the privilege. So you don't specifically have to say that you are
Pleading the fifth. It
But
does sound cooler, though.
But you do have to make it known that you do not want to. That also comes up in when you're talking to the police, that you need to make them aware that you are pleading the fifth, whether you say you're pleading the fifth or you say that you refuse to answer any questions. You need to make them aware that that's the stance you're taking. 1958, multiple sentences allowed for multiple convictions. Gore, not Al Gore, versus the United States. The Supreme Court rules that the Constitution is constitutional for a defendant convicted of multiple crimes arising from a single act to be sentenced to serve multiple prison terms. In this case, a defendant was convicted of 3 different crimes arising out of drug sales made on 2 consecutive days. For the crimes committed on the first day, the defendant was given 3 sentences to serve consecutively. The 3 sentences for the same crime committed on the second day would be considered to be served concurrently. And that's with double jeopardy. If you're tried for murder and you're acquitted of murder in the first degree, you can still be tried for murder in the second degree. That's not what this is saying. I'm just talking about it. So you can still be charged with a lesser crime dealing with the same crime, but you can't be retried. What if you're acquitted?
They have to charge you at that one trial, not a new one.
I think so.
But they'll charge you with everything from like assault to murder.
Yeah.
And then the jury will decide which one applies.
And then if there's a mistrial, you can be retried for the same crime. It's just if you were acquitted, you can't be retried for that same crime. And then this is just saying if you were tried for multiple crimes dealing with one incident, that's not double jeopardy because those are different crimes. Different crimes dealing with the same crime. I'm not sure how to word that.
Yeah, that one's... I don't quite understand it, to be completely honest. Especially the sentencing. The first day is served consecutively, and then the second day's crimes are served concurrently? What's up with that? I don't get it.
Yeah.
Moving on.
I kind of understand what it's saying, but I don't. I understand the text of what it's saying, but not the law behind what it's saying. So one of them, they're served back to back, and then the other one, all of them are considered served at the same time. So consecutively would be 10 years, then 10 years, then 10 years. Concurrently would be you've got 3 10-year convictions, but one service of 10 years covers all those 3.
I understand it now.
1959, the ability to practice chosen profession cannot be taken without due process. Yeah. Wow. I think you were right. This did take.
We're not even halfway through.
Yeah. So on this one, it was an aeronautics engineer lost his security clearance, so it kind of tainted him, and he couldn't do aeronautics engineering. And he was saying that losing that clearance deprives him of his right of his chosen profession. 1960, court expands property for which the government must pay just compensation. This is actually kind of interesting. Armstrong versus United States Supreme Court holds that the Fifth Amendment's taking clause applies not only to land and real estate, but to more intangible property, such as financial interest. Has to do with a shipbuilder, and I think they canceled the contract, and it had to do with that, something like that. Second company, supplier complained that so this company that was supplying the materials complained that government basically had taken the supplier's property now I confused myself. The company turned over the government's partially completed ships and the remaining building materials to the government could finish the job. So they gave the ships and the materials to finish the ships to the government, and the court case was over getting paid for that, and saying that if they didn't pay, they'd be taking their property.
So the second company probably had payments that original company was paying to them for the supplies they gave.
Well, I don't. Yeah. So they were owed for that, and the court agreed that they should be compensated for that. 1961, government employment can be denied without hearings. And there was, that had to do with I believe it was a cafeteria worker. The base commander banned that person from the base because their security clearance. And the court said that was because the base commander had, it was his duty to ensure the security of the base, that he could do that, basically. 1964, state defendants also have self-incrimination privileges in Malloy versus Hogan. United States Supreme Court rules that the Fifth Amendment's right against self-incrimination, which historically applies only to witnesses in federal trial, also protects individuals testifying in court. So here we see a change, a little. And some of the changes are small technical changes, which
that's how we get here.
Yeah. So you'll see like if a case gets thrown out and there was one small technical problem, you'll see that everybody talk about the case being thrown out, but it's because of that little technical problem. So technicalities are huge in court cases. And so I'm not sure if this little piece that's a little bit different than earlier that we read about the protections not applying to state courts. In this case, it does apply to state courts, but under this ruling, is that everything with state courts or just this something that applies to this case? Something similar to this case.
Well, I'm going to guess, since it's the 1960s, this was the civil rights era. This is when we kind of retooled what states were allowed to do to its citizens. I think that might have a big chunk to do with it. But I mean, it took 180 years to get protection from the state government. Shit.
Yeah, and part of that is when the whole thing started, each state was basically, they were almost nation states. And So we're a confederation of sorts, and so they were looking for protection from a central federalized government, which was the surrogate um, king.
Yeah, they're worried about federal government. They still wanted all the power
Yeah,
running their states.
and that's we'll probably talk about that to end the
Hmm.
series. Is states' rights versus federal rights. You know, the centralized government, versus state, and all that. But that's I kind of lost what I was talking about. Um, so we'll move on. Uh, wow. Whew. Yeah, we're not
There
gonna
we go.
finish
Let's go
this.
to the 2000s.
So, uh, let's skip ahead a little bit.
We just go off the titles.
So this one, I think we'll cover this one. 1966, due process rights for juvenile offenders upheld. In Camp versus United States, the U.S. Supreme Court rules that juvenile offenders are entitled to a full hearing before their criminal case can be transferred from juvenile justice system to the adult system. The court recognizes that juveniles accused of crime may be procedural need as many procedural protections as justice systems as adults do. The court reaffirms this. Blah blah blah. I think this was a case where a kid was, I think, murdered people, and then was going to be tried as an adult. I can't remember if the case had to do with that, or if I'm thinking of one where they went before the Supreme Court to see if they could actually be tried as an adult. I don't remember exactly. 1966, loyalty oath is struck down. I'm not huge on loyalty oaths.
Yeah.
That's F. Brandt versus Russell. So this is one of the landmark cases. 1966, Miranda versus Arizona. You have the right to remain silent. The U.S. Supreme Court rules that the Fifth Amendment right against self-incrimination is not limited to in-court testimony, but also applies when a person is taken into police custody for questioning. The court also rules that the criminal suspect must be told of their Sixth Amendment rights to an attorney. Once a person indicates in any manner that he does not wish to be interrogated, the police must stop asking questions, even if the person has answered questions up to that point, the court says. So you can invoke your right uh, at any point when interacting with the police. And then, even if you have started answering questions, you can stop. If you
Yep.
have stopped and then feel like you want answers, you can um, waive your right at any time. But if you have waived that right, you can still go back and then invoke it at a later time if you want to. And that has become known as the Miranda rights. And that's the little cards that the cops read from to tell you what your rights are. There is a later case, which it's a more recent, where
2013.
you cannot sue a police department if they do not read you your rights. The case can still be thrown out, but you cannot sue in a civil court over it because they're not liable for forgetting to read you your rights.
That might not be the 2013 one.
Yeah,
So it only took us 175 years to.
I think it was from like
that.
last year. It's really recent. Have a good night, Iron Road. G23 saying, hopefully you're ready for 6 hours. No, we're gonna skip ahead and won't cover them as in depth as we have been. We'll make it through it within the next few minutes, hopefully. So defendants cannot be forced. Double jeopardy applies to state trials. 1969, Benton versus Maryland. The U.S. Supreme Court rules that double jeopardy clause represents a fundamental idea of our constitutional heritage and extends double jeopardy protection to defendants in state court trials. The justices also cite the 14th Amendment prohibition on state governments limiting liberty without due process. Double jeopardy, the court rules, violates due process rights of the accused. The 14th Amendment was kind of big. Not just, it was implemented after the slaves were freed to protect them, but it helped further protect everyone.
Yeah, it's got 5 sections. That's not going to be fun to read.
Yeah. Skip. So 1978, second trial allowed if charges dismissed in mistrial. That's U.S. versus Scott.
Mid-trial.
Oh, mid-trial. Sorry. The Supreme Court decides that a defendant who won a dismissal of charges against him before the jury issued a verdict can be tried a second time if the prosecution wins an appeal of dismissal. The court says double jeopardy protections are not violated if the grounds for the dismissal are not related to factual guilt or innocent.
Okay, that makes sense.
So there was no finding. So you're not being double jeopardied. I think this is the most I've ever read on air on a chat.
Yeah, this is that's a lot.
It's getting tougher.
Give me a takeover.
I only have so many words I can say in a day, and I'm using them all up. Yeah, why don't you take over for a little bit?
1980, windfall benefits for only certain rail workers are upheld.
Well, I didn't stop on that one. I was just taking a drink. So we'll move on.
Court says draft registration may exempt women. What that's got to do with the 5th? The Supreme Court upholds the Military Selective Service Act, the draft, required that men ages 18 through 25 register for the draft. In blah, 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 the court rejects the argument that exempting women from the act violates the right of due process under the 5th Amendment. How would that be a thing? The court says that the exemption is not the accidental byproduct of a traditional way of thinking about women. Were they fighting for the right to get drafted?
That's still 81 would still be in the women's rights push.
Women, it holds, are not similarly situated for the purpose of draft registration because they are barred from combat roles. The court says that the problem that would be created by drafting women in non-combat roles were sufficient to justify their exemption. That's weird, isn't it?
Yeah, I'd have to look up that case, but I'm not going to look up that case. I will not do my due diligence. I'll admit it.
I want to stick on that. What type of a woman would be like, I want to fight for the right for all women in this country to be drafted into a war?
Well,
What the
yeah.
fuck?
Now you're gonna make me look it up.
Yeah, I can't believe that. It was probably like some senator that got drafted into Vietnam. He had a bone to pick. He's like, those goddamn women didn't pull their weight.
See if I can find.
Watch somebody clips that. Definitely don't make a short out of that.
So, yeah, it's not the one of the really good resources is lawcornell.edu for Supreme Court cases, but they don't give you a summation, which is what I'm looking for.
You know, I'm curious about. We have women in combat roles now.
Yeah.
So isn't this totally not a thing anymore? They get drafted now.
Actually, it was
By this thinking, they could get drafted.
Robert L. Goldberg challenged the act as gender distinction. So it was a guy that brought the suit.
Did he like manufacture women's combat fatigues or something? He was pissed off at all the money he wasn't making.
I don't know.
I just can't figure out why someone would want to fight that. Right? Doesn't make a lot of sense. I'm doing this for you, women.
So it was an anti-war group that brought it.
What? We must be missing something, because this doesn't make any sense.
The only thing I can think of is they were trying to get rid of the draft itself by attacking it as sexist. Basically.
Wouldn't that have been tragic and hilarious if by attacking it, they made it so all women can get drafted and they fucked over everyone instead of saving men?
But
not smart.
Wasn't it Carter that abolished the draft?
So
is this just...
I don't know.
This one's confusing. So this must just be registering for the draft, not the draft.
Yeah, because that's still a thing.
Yeah, because you still have to register, but there is no draft. You register in case there ever is a draft. I'm a little confused on that one.
I think everyone is.
We'll skip it. But that's from the very quick look I looked at it. It looked like it was, it was an anti-war group, and they were probably just trying to abolish any draft or potential draft.
Public beach.
Multiple prosecutions cannot arise from a single act if based on the same conduct. So drunk driver.
Miranda not required when police are undercover. No shit.
You have to tell me if you're a cop. Do people actually believe that, or is that just you see it in TV shows? Comedy.
I don't know. Well, you remember the clip we watched the other week?
No.
The cop was in uniform buying weed.
Oh,
like,
yeah.
Here you go, man. Feel better. He's like, you're under arrest. Like, yeah, good one. No, you're under arrest. Fuck.
Prosecution 92 prosecution for conspiracy to commit a crime and for a crime itself is upheld. Supreme Court rules that it is not double jeopardy to violate for prosecution in an Oklahoma trial to use some of the same conduct that was used against the defendant and prosecuting him for same charges in a Missouri trial. So he was tried in two different states and basically used the same evidence, and it's not double jeopardy. Loss of all economically beneficial uses of land equals a taking. 1993 court overrules same conduct test.
You know what I think? I think we should skip to 2013.
Yeah.
90s don't matter.
That would seem to contradict that ruling which we just read about. So what's the last one? 2013. Silence before Miranda warning may be used against subject at trial.
He didn't say anything before I gave him his Miranda rights, so he's fucking guilty. Yeah. God damn it.
The Supreme Court decides that in Salinas versus Texas, that a suspect's failure to answer a police officer's question before he was arrested may be used against him, may be used against the suspect at trial. The case involved Genevieve Salinas, who was convicted of the shooting death of two brothers. Before his arrest, Salinas agreed to answer police questions, but was silent when asked specifically about his shotgun and shells removed at the scene. At the trial, the prosecutor pointed out Salinas' silence on the question, saying it showed he was guilty. The court says that since Salinas agreed to answer questions before he was arrested, he was not entitled to Miranda rights, nor could he invoke the right against self-incrimination. So he was not under arrest. So the Miranda rights do not apply.
This is why you don't talk to cops at all, ever.
So he had not been seized at that point. So I kind of understand it. Maybe don't agree with it, but I understand the technical application in this example. Wow. So that was an hour and 15 minutes on something I was worried we wouldn't make 15 minutes out of.
Yep.
But the Annenberg classroom does give you a pretty good view into the timeline and then some of the important happenings, court decisions dealing with the Fifth Amendment, or with the amendments, with the Constitution. So
G23 doesn't have a link.
Well, G23 needs to go to the Gilded, which he is a member of, and get the link from there.
Well, you do something fun. Just drop it in the YouTube chat. See who shows up.
I don't know. Yeah.
G23 can't figure out Gilded.
He's been on there. I've seen him talk.
He has his own server.
Oh.
There he is.
I'm not here.
X Adam 1 wants me to do a desk pop.
Should I?
Um,
No stones if you don't.
we'll save it for the end.
I might get the cops called on me because it's the middle of the night. If it was daytime, I'd do it.
Oh, definitely you'd get the cops called on you. They don't matter daytime or nighttime. I know what state you reside in.
I have done multiple desktops in a row, not have the cops called with rifles. So I guess my neighbors were like, oh, I guess he just murdered people. That's okay.
Hey, we're not going to ask questions.
Hey, a good neighbor minds his own business.
A better neighbor comes over to help you dig the holes. I mean,
So any comments on anything we've covered?
So
Don't talk to cops.
that's a good one. But depending on the mistrial is if you can or cannot be retried. So yeah, I mean a mistrial with prejudice. You're not going to be, and then if there's a mistrial because of prosecutorial misconduct, you won't be retried. So there are some mistrials that will automatically disqualify being able to be retried for the crime.
Is that what happened at your trial?
I can't talk about what happened.
This is where we get a penis cam.
No. I know who that is.
Do we, though?
Yep.
Anyone can type the username.
Hey, if you tell
Yankee
people,
Marshall shows up.
Are you a little nervous, Foss, that the link may or may not have been thrown out in the comments?
Not really, because I still control who comes in or doesn't come in. In fact, so if I didn't want somebody to be in here, they wouldn't be in here.
Fifth Amendment.
So what'd you
Yeah, should
talk
we-
about? What'd you talk about on your chat? G23. What did I
Nothing
miss?
important. Nothing important. Somehow, New York Outcast and I kept the show running for over 3 hours with absolutely nothing really. And we did talk a lot about me not buying the white flowers and how I'm a savage because I refuse to buy the white flowers.
I laid down for a nap and got up in time to do this chat. So let me show this before I forget. Something that Ron Wayne sent in. I gotta show. There we go. And he said he ain't afraid of no ghost.
Gun.
Made in the USA, Dayton, Nevada.
Can we find any of his fingerprints on the slide? We can zoom in on.
Oh, I don't know. Yeah, there's a smudge there. Smudge there. Maybe.
I remember when we were allowed to build those. Fun times.
I have no clue what you're talking about. Um, I'm pretty sure that those were never able to be built. I'm pretty sure that that's a 100% manufactured and purchased from an LGS.
They do some with serial numbers on them. So you never know.
I guess I can stop sharing the blank screen. X Adam 1 says you have to trust in the system to believe in these laws and rights. They seem to get violated pretty often without consequence.
Yep.
Fortunately, too often. And I don't know, is it bad to say it's still the best system there is with all its flaws?
Yeah, could be better.
Do you measure against perfection, or do you measure against the other options that are available at the time?
Well, we should strive for perfection. I'll say that.
I'm just saying, anyone that doesn't like our judicial system can go and spend 3 years in North Korea and see what kind of judicial system they get away with.
I do kind of fall in line with the however many guilty go free rather than having one innocent be jailed. However that saying goes. And it's, a lot of cases, Supreme Court cases that you'll see dealing with this, they are not good people. But protecting their rights protects the rights of everyone. And so it is the balance that you have to strike. That yes, this bad person may get out, but it protects innocent people from being put in.
Yeah, I don't think of it as protecting that one person who's a jerk as much as restricting the government from using anything available for them just because that person's a jerk.
And
Right?
I hate,
Otherwise, an unscrupulous government could say, "Hey, well, there's jerks out there, so therefore nobody can have anything good." Stop the jerks.
I hate when a bad person, when their rights are trampled, that you'll hear people say, well, they're probably guilty of something else. Well, it doesn't matter if they're guilty of something else. They're being tried or accused of this thing. And again, go ahead, G-Webs.
I was just going to say, I know we're trying to be polite or whatever. Can we just drop the facade and say, when we're talking about bad people, we're talking about 9mm shooters?
Yeah, some of them. You have to protect everyone's rights, or nobody's rights gets protected. It is kind of an all or nothing. Yes, there are people who are less likely to have to deal with any of these consequences. But, it has to protect everyone. Otherwise, it protects no one.
I can tell you that. I can tell you that from personal experience, if you're not causing trouble and you're not doing stupid crap, you don't really have a whole lot to worry about, because you're not really going to get harassed. And I've been on both sides of the coin where every law enforcement officer knew me by first and last name and would refer to me by my last name. And then I've had it where they knew me by my first name. And, being treated differently because, hey, you're not out there committing crimes. You're like, I guess they're not just gunning for me. I was actually just doing something stupid.
X Adam 1 says, as we look down on some people for being lesser, someone else is looking down on us for thinking the same thing. Bad is based on whose ideology? And I don't like the inequity of the system, referring to elites versus the rest of us poors. And that's the way it does seem that, if the more money or influence or notoriety you have, that, the more rights you have. Well, that's not quite what I'm meaning, but they are viewed differently. A recent example is I don't know what came of it because I haven't looked into it, but on the face of it, like Nancy Pelosi's husband, before he was hit with a hammer, but his drunk driving. How many times do you see that? Like if a police officer is pulled over for drunk driving, there's maybe not the same consequences as if another citizen gets pulled over for drunk driving because of who they are or who they know.
I've seen it be different based on sex. I knew a guy that got pulled over for drunk driving, didn't hit anything. He got put in jail. I know a girl that T-boned somebody drunk driving, not a day in jail.
That is a thing.
Yeah.
And I don't want to get into that.
I know a guy that got a DUI, got released on bail, got another DUI, and so they raised his bail like $20,000 more. He got released on bail again and got another DUI, got released on bail the third time on like $100,000 bail, and then went out and killed somebody.
Yikes.
Killed an 81-year-old woman who was getting cat food for stray cats at like 5 o'clock in the morning.
Vanessa Kitty's out there. Good morning. X Adam saying politicians commit crimes that affect thousands when they steal and don't do jail time. Poor gets arrested for weed or petty theft and they get 2 to 5 years. Yeah. Unfortunately, yeah. Oh. So, I think we're out. I think we're out of stuff. Hopefully this wasn't too dry for everybody. It was kind of a tough one to research because it was hard to find the court cases, and
Is there anything that you discovered or like learned in the research?
there was the fifth not applying to state courts. Something I hadn't really thought about, the difference in state and federal, how that applied. That was a kind of surprising.
Yeah, it's no bueno.
X Adam saying I should use my big YouTube money. I'm not monetized. I don't have any YouTube money.
We lose money being on YouTube.
Yes, this is a loss leader. This is all just it's not even a loss leader because I don't make money off of anything else.
But we're not sponsored.
But if you had more channels, you could make it up in quantity.
Yes, I bring you the savings through volume. I don't know if there's any big revelations, but little small things that were interesting that I hadn't thought about, like that or applying to kids, and that's I don't know. That's one thing. Just speaking of courts and trials and stuff, and more defendants, kids that murder. What do you do with kids that murder? Are they redeemable? Do you try to redeem them, or do you just charge them as adults and lock them away? Does the age of the child make like 7-year-old versus a 12-year-old?
Well, it's the circumstances, right? Like,
yeah,
if the kid got forced into it or was put in the circumstances versus some kid just came out of nowhere and started being evil.
I mean, I think adults that murder are still redeemable. So, in most cases.
Yep. I mean, I know a case. I know a case where 2 kids were playing on train tracks, and a hobo threw a rock at them. They got pissed off, and they pulled a gun and shot the hobo. And they were charged as adults.
This stuff I think about that I don't have answers, and I'm not sure who to ask to ponder over. I do believe in second chances. I think everybody deserves a second chance. And then after that, we'll see. C&T Designs and Arms is saying, if you murder, you forfeit your life for the life you took. I understand that viewpoint. And that's with capital punishment. I believe it needs to be the strictest standard of any.
Well, you're painting something on the side of a building and the paint can falls off, knocks somebody in the head, and it kills them. Are you got to die because of an accident?
Well, I'm just talking that, in a murder trial, that there have been people convicted who were innocent, and there have been people that were put to death that were innocent. And I have changed a little bit on my view on capital punishment. I'm still not against it, but the standard needs to be
The funny thing is, the higher you make that standard, the more it costs, and then it's cheaper to just house them for the rest of their life. It actually costs more money to kill them. And then you're giving the government the power to kill its citizens.
And you're giving them that authority and that obligation, right? That requirement. And then there's just people that are broken and sick, and they're going to kill because they don't understand, right? And now you're doing something. And in that case, the reason I say that is because that person isn't going to be dissuaded by the history of other people being broken. Yep. They're not going to understand that, and they're not going to be dissuaded. So
it's not a deterrent.
It stops some people who are already going to be stopped in the first place, but now you're giving the government this authority based on people who are never going to be dissuaded by it in the first place.
Yeah, Coop is saying for capital, the burden of proof has to be 100% unquestionable.
Now, if it
I
is
mean-
somebody who's like, well, I'm going to play the odds, I'm going to do this and that, I'm going to act like I'm on balance, so I'll get out of this. But if the alternative is a swift end or the rest of my life doing work or having to repay these people, so maybe spend the rest of your life in some kind of labor with the results going to pay off your victims, right? So now there's actually something being done, and that person has a chance to amend, maybe not be free, but a chance to amend in their own mind for what they did wrong, or whatever. But that's their issue. But what's the bigger dissuasion for somebody who's in a non-messed up, not a broken state of mind, but in a calculating state of mind, being alive for the rest of their living life, doing work for for whatever they did as a consequence, or quick end. If they see that, oh, life's over, I hate everything, I'm going to go out in a blaze of glory, I don't care, right? Then again, killing them ain't going to stop nothing. That's not dissuading them. But, oh, I'm done, I'm going to go out in a blaze of glory, and then spend the rest of 40 years in hard labor, a little bit different dissuasion, or whatever the word is.
Yeah, I agree.
Yeah, and that, I don't want to start getting into that because that'll take us into.
Well, is that another amendment, or that's not even in the amendment?
Cruel and unusual punishment. Isn't that the 8th?
That's
It
one
might
of
be more towards that, yeah.
that's one of the arguments against capital punishment.
Yeah.
Yeah, but so I think we'll close her down.
Tune in
So-
for that chat. That could get lively.
Appreciate everybody that was watching. And those who watch this in replay, and I appreciate you too. And here, just for X Adam 1, here's your desktop. Get it just right. There you go. So yeah. Anything else? Anything you guys want to plug before we go?
Making a new brand of soda called Desk Pop.
There you go. Tastes like
Coming up with
Corda.
different flavors.
G23, anything you want to plug?
I have a new video on Patreon, and maybe I'll have a couple videos coming out in the next few days.
All right. Other than that,
Have a fun and safe Halloween.
yes.
Invented a new thing. I got this air popper, put popcorn in it, and it makes air popcorn. So you ever had one of these things? You know what I'm talking about?
Yeah.
So while it's popping, when you get the first layer of popcorn, but it's done being kernels and you got some white popcorn in there already, I'll squirt a whole bunch of hot sauce in there and then let it keep going. You ever tried that? And then it'll
No.
turn it into hot popcorn. It's pretty awesome.
Ah,
You can do it about 3 times while it's popping, and then it kind of the what do they call that? Like the chaotic, what happened? As they're bouncing around in there, they distribute the
yeah.
hot stuff all around. It's freaking awesome. It's really good.
Oh, all right. Well, I hope everybody has a good. Oh, hey, if you're up a little bit later in the morning, Gizzard Gary's doing his early bird chat, 7 a.m. Pacific. Was that 10 Eastern?
Is that guy still doing that?
I think so. It's if you ask him nicely, he can probably be on the chat. So if you're up later, check him out on the Gizzard Gary's YouTube channel. And I hope everybody has a good rest of the night.
You still here? It's over. Go home. Go.